So what's my research question? What's the research question that I'm studying here in this topic? The research question is, under what conditions have transnational actors been successful in affecting domestic policy change, in this case in the country of Bosnia-Herzegovina? And by transnational actors, we mean both state actors, like the United States, various members of the European Union, the European Union itself institutionally, also non-state actors like the United Nations, civil society groups, etc. That's our transnational actors. The main transnational actors I'm going to be focusing on, and I focus on in this study, is mainly the European Union and the United States, and what they've tried to do in terms of, well, tried to do many things in Bosnia-Herzegovina, but at least what I'm interested in this topic, what they've tried to do in the realm of criminal procedure reform, quote unquote, since 2003. So policy area under study, the attempted transformation of BIH's criminal procedure code from a civil or inquisitorial model based on, the French model, post-revolutionary codes, the French model, the continental model it's also called, to a more Anglo-American, sometimes called accusatorial model. And what those models entail, I'll discuss in a second. Well, I'll discuss it right now. So what are the defining characteristics of this inquisitorial/continental model of criminal procedure and this accusatorial/Anglo-American model of criminal procedure? Well, inquisitorial, hierarchical bureaucratic decision-making, broad evidentiary rules, and a reliance on written records. And to any of the lawyers or legal academics here that are from Serbia or from the region, I mean, this shouldn't be anything new, right? Because most of the region still follows this inquisitorial model. I know there's some changes in the past 6 or 7 years in Serbia, minor changes trying to move away from this model in certain issue areas dealing with organized crime, but on the whole, Serbia is still very much classified as an inquisitorial model of adjudication, like France, like Germany, like Italy, like Greece, etc. There's some minor differences between, all these countries that entail the model. The pure example usually trotted out, at least for us who study criminal procedure, is France. Germany is a very bad example these days because they've gotten rid of some of the aspects of this model, even though we still classify them as inquisitorial. Accusatorial, Anglo-American, right? Party influence, discretionary decision-making. So it's the parties that are really influencing the decision-making, that are introducing the evidence through their dueling accusatorial lawyers, the prosecution on one side, the defendant on the other side with their defense lawyer, strict evidentiary rules, and a reliance on oral arguments, right? It's the idea of the stuffy English barrister or the slick American lawyer in his $1,000 suit. It's all about oral argument. Yes, there are written records. Yes, we have a written record, but the evidence is proved at trial, right? Orally, through oral arguments. So that's the inquisitorial divide. The puzzle. So we have criminal procedure, at least on paper, at least in theory in Bosnia-Herzegovina, pre-2003 and post-2003. So pre-2003, the model is based on the 1977 Yugoslav Criminal Procedure Code. Post-2003 is based on the BIH Criminal Procedure Code. Pre-2003, again, it's an inquisitorial model. You have this mythical figure of the investigative judge that runs the investigations. We don't have a figure like this in the Anglo-American model. Investigative judge, the way it was explained to me many, many years ago when I was learning about the system, because I'm an American trained. Well, I used to be an American. I'm American trained. I used to be a lawyer. I'm not a lawyer anymore. But I'm American and American trained lawyer. So when I was learning about the system, the way it was explained to me in this country, actually many, many years ago, is that the investigative judge is, part cop, part judge. Think of like this super investigator that has all the powers of a judge. They can subpoena witnesses, they can compel testimony, and it all is entered into a record. But it's a written record in the sense that, yeah, like testimony can be oral, but it's all taken down by the stenographer and is put into this mythical written record that Mirjam Damashka and Bob Kagan call the dossier, Službena beleška, right, in Serbo-Croatian, and it travels with the case through the various levels. So yeah, evidence is given orally many times, but it's put in a written record, it's written down, it's put down, and it's put into this record. And you have this mythical figure, the investigative judge, in theory, that runs the investigation. So for an American, for me, that was interesting because where I'm from, the prosecution runs the investigation. No. In the inquisitorial model, whether it be in France, I'm not going to use Germany because they got rid of the investigative judge, but whether it be in France, whether it be in Austria, let's say, whether it be in Serbia, whether it be in Bosnia-Herzegovina before 2003, it's the investigative judge that runs the model, that runs the investigation. Now, once you get to the trial level, the lawyers, they're not completely silent. They do speak, you do hear from them. But at least for an American trade lawyer, for me it was very strange because most of the talking, most of the questioning, most of the interrogating at the trial level was done by the judge. And I'm used to judges, at least where I'm from, they don't say very much. They do a great deal, but they don't say very much. It's the lawyers that do the questioning, that bring the witnesses up, that examine and cross-examine. No, in this model, lawyers can examine. There's no such thing as cross-examination. I remember once trying to explain the concept of cross-examination to a Bosnian lawyer, and once I finished explaining it to him, he said, "That sounds very rude and ungentlemanly. I would never do something like that." How would you even do something like that? You have to be respectful to the witnesses. I said, "Even if they're not your witnesses?" He said, "Well, yeah, even if they're not your witnesses." Post-2003 in BIH, we get rid of the investigative judge, at least on paper. He or she no longer exists. It's the prosecution that runs the investigation. It's an adversarial system. The defense, their lawyers can run, if you can afford it, you can run your own parallel investigation. You present your competing versions of evidence at trial. You don't have this in the inquisitorial model. There's no competing sets of evidence, competing sets of experts that you call. It's the judge that chooses one set of evidence that's going to enter in and one set of experts. So a lot of the times American juries, they're very confused. They don't know who to believe. O.J. Simpson trial is a great example, right? Very famous example. Prosecution trots out scientists who say, yes, this blood is his, this DNA is his, this man murdered these people. And you have the defense that trot out their witnesses, their experts, who also have degrees from very famous universities, are also well-established experts, and they tell the jury, who are, again, 12 ordinary men and women, no, this isn't his blood, 99% probability, this isn't his DNA, so who are you supposed to believe? But that's the accusatorial system. And again, post-2003, at least in theory, you have examination, you have cross-examination, the judges largely stay silent, and everything is now supposedly orally proved. So what I was trying to test is, did these changes actually take hold, and how, and why? And if they didn't, how and why? Framework. What's the framework that I use? And it's an interdisciplinary framework that seeks to improve an understanding of the key factors that influence the ability of transnational actors to affect domestic state behavior and how you can measure these things. The framework I use is from Halliday and Carruthers, Terry Halliday, Bruce Carruthers, two sociologists, they're not lawyers, two sociologists out of the American Bar Foundation in Chicago. And building on classic socio-legal theory, they say, look, law isn't what's in the statute books. It's not what's in the judgments if you're going by the common law. That's part of it, but that's not the entire story. Law is law in the books, law in the statute books, or law in the judgments, that's part of it, but it's also law in action. So Lauren Edelman, who's very well-known socio-legal theorist, who really kind of spearheaded this in the mid-'80s, she was studying discrimination law in the United States, and she said, look, the statute says one thing, but it's how the statute is put into practice by the corporations that it affects that have to follow the statute and not sexually discriminate against their employees. That's what the law actually is. Part of it is what's in the statutes. Part of it is compliance, how the in-house lawyers in these companies and in these corporations comply with the statute. So if you want to know what sexual discrimination law is in the United States, you can't just look at the statute. You have to look at law in action. So law in the books, but also law in action. So this is nothing new in socio-legal literature, but what Halliday and Carruthers say is, okay, look, you have formal law, cases, statutes, regulations, and law in practice, implementation, legally constrained behavior, etc. But they say, let's move away from the domestic level. Let's move into the system level as well. And you have all these different actors, transnational actors, let's call them, professions, supranational discussions earlier today about the ICTY and ICJ, etc. Legal complexes, NGOs, international financial institutions, etc. And when these different norms, let's not call them laws anymore, when these different norms are floating around on the international level, they're not always settled. What's a crime against humanity? This is a great example because it's one that's part of my case study. What's a crime against humanity? Or what actions constitute crimes against humanity? We're fairly certain now to an extent, but there's still a lot of confusion. What does that mean according to Halliday and Carruthers? That means that these norms haven't settled yet. They're still bouncing around these transnational actors in the international system. They're still bouncing around these internal systems within the nation states, and they're still being developed. So they're still being developed. Law and action, law in the books, they're still fluctuating and being developed. And there, at least as far as I'm concerned, their great contribution is they say you have these recursive cycles, the norms are fluctuating and circulating between these different actors, bouncing around, and they're being developed. It's not a given that this happens, norm-making episodes. Sometimes they're very short, and then the norm becomes very established, and then everybody knows what, let's say, crime against humanity is a bad example because it's not settled. But everybody knows what constitute the elements of a genocide. Everybody knows what constitutes the elements of a war crime, the various acts and the mens rea, the actus reus, etc. They're settled. If there were norm-making episodes, they no longer exist. They've come to a stop, and we all know and understand what these norms mean. But other times, norms are not settled, and so they're going through these refractive, recursive cycles. There's a time one when they're competing claims as to what these norms mean, and a time two when these cycles come to an end, and we all understand, for better or for worse, we all accept what these norms mean. And their great contribution is how do you determine whether these norms are settled or not? You look for these mechanisms that drive recursive cycles. Indeterminacy. We're not quite sure what the law means based on the wording of the law, whether this wording comes from a statute, whether it comes from a set of judgments from some international tribunal, whether it comes from the writings of well-known jurists, whether it comes from customary international law, custom and usage, whatever. We're not quite sure what the words mean. Contradictions. Different actors have come together to construe these norms. They couldn't agree on a final idea of what the norm should mean, so they just came up with a contradictory norm so they could wipe their hands of it, all claim victory, and move forward. Diagnostic struggles. Different actors are diagnosing the problem differently, so they're interpreting the norm, and they're coming up with a different meaning for the norm. An actor mismatch. The actors who came together to create the norm are very different from the actors that are affected by the norm and have to implement the norm. So there's mismatch there, and so the people who created the norm or tried to create the norm, they have one set of ideas, and the people who are implementing it have another set of ideas. So if you want to, at least for Halliday and Carruthers, if you want to try to figure out what the norms mean, if there are these recursive cycles ongoing, try to look for these mechanisms. If they're there, well then you have recursive cycles, the norm isn't settled. If they're not there, maybe the norm is settled and you kind of know what it means now, whatever the norm is. So here's my framework, stage one, institutionalization of norms. I took these norms that transnational actors use as a vehicle to implement criminal procedure reform in BIH. These were the recognized international criminal offenses of crimes against humanity, war crimes, and genocide. Stage two is institutional mediation. I looked at the institutions these norms were filtered through, different sets of courts in different parts of the country that had very different institutional makeups. Stage three, policy outcome. Was there any difference? In one set of courts, did we have an actual change to the New Anglo-American model? Or did we not? In a different set of courts, did we have a different outcome? And I'll go through those very soon. Research design. So what was my research design? So we're going to test whether legal recursivity, this Halliday and Carruthers framework that I've just been talking about, and or institutional design, stage two, have any bearing on the ability of transnational actors to change the procedure through which criminal cases in PIH are adjudicated. So how did I conduct this test? I looked at the entirety of the collection of the judgments of the Central Government State Court of Bosnia-Herzegovina from 2004 to 2009, all the adjudicated cases, all the judgments. That was 48 of them, n equals 48. Then I looked at a different set of courts, and I'll go through, hopefully if there's time, and I'll go through how these different courts function and what their different institutional makeups are. I looked at local district courts that are very different from the state level court in the Republic of Srpska, n equals 21, and cantonal courts in the Federation, n equals 37, arising from international criminal offenses from the 2004 to 2009 period. You have these international criminal offenses of war crimes, crimes against humanity, genocide. They're also part of domestic Bosnian law. Yes? All three institutions are empowered to hear cases of criminal offenses conducted in the territory of the former Yugoslavia during the conflict of the 90s. And all three courts are meant to apply in theory the same criminal procedure, right? The same post-2003 criminal procedure. But as I'll discuss, the outcome has become actually very different. Some courts are applying it, some courts are not. And the institutional design of the three courts is very different. The judgments were coded according to the doctrinal issue of international criminal law they dealt with, crimes against humanity. I tested for the presence or lack thereof of recursive cycles by looking at whether those mechanisms that Halliday and Carruthers identified were there or not. Looking at war crimes in international legal jurisprudence, crimes against humanity, and genocide. So if we look at war crimes, do we have any of these mechanisms? Indeterminacy, contradictions, diagnostic struggles, actor mismatch, etc. Same for genocide, same for crimes against humanity. The test for legal recursivity was joined by a set of specifically constructed measurement indicators that I'll discuss in the next slide, designed to capture the unique characteristics of inquisitorial versus accusatorial models of legal adjudication. And this is the model, because, okay. I couldn't go back in time and actually sit in all these cases and see which criminal procedure model was being followed. All I have is the judgments in front of me. So looking at the literature, mainly Damashka and Kagan, Bob Kagan, we determined that inquisitorial adjudication is characterized by hierarchical decision-making, formal decision-making style, accusatorial, participatory decision-making authority, formal decision-making style. So what? How do you break down these concepts into things that you can measure in the actual written judgment in front of you, in my case on the computer screen? All right, inquisitorial. Do I have a single case file or dossier of evidence proofed into the judgment or record when I'm looking at this judgment? Does the judgment contain what Damashka and Kagan call logical legal reasoning, referencing mainly statute, treaty, goal being connect the facts to the relevant body of law in order to create a solution that's generalized and not tailor-made? Accusatorial, duplicate evidence collected by each side, discussed and evaluated within the judgment. Judgment contains variant of pragmatic legal reasoning. Again, this is from Damashka and Kagan, referencing mainly case law. All right, stage one, institutionalization of norms. I'm running short of time. They're in the slides. I'm happy to send them to you if you like. Happy to send the draft paper to you if you like. But long story short, crimes against humanity, just take my word for it, because I'm running short of time. You have recursive cycles. Genocide and war crimes are fairly settled. International lawyers and jurists are fairly settled on what genocide and war crimes are. Take my word for it. Okay. Institutional mediation. I'm just going to zip through these slides. You have three very different institutions, and I'm going to wrap up in the next 2 minutes. You have the State Court of Bosnia-Herzegovina that's kind of floating out here, kind of independent and not really answering to any other institution. You have these district and cantonal courts that are part of the legal hierarchy, and ultimately you can appeal their decision to the Constitutional Court of Bosnia-Herzegovina or the entity level Supreme Court. State Court of Bosnia-Herzegovina is sui generis. The appellate level is located within the court itself, so the institutions are very different. Long story short, I looked at the judgments for the state court, and I found that when you're segregating them according to the issue area they dealt with, crimes against humanity, war crimes, genocide, it doesn't tell you anything. You don't see any patterns. When you get rid of that segregation and just look at, I'm not going to segregate the cases anymore. Accusatorial, inquisitorial. Something happens. You see, in 2006, something happens. Suddenly, accusatorial is taking over and inquisitorial is not. So something happened in 2006. When you look at the district and cantonal courts, you notice that there's a very clear pattern. There's no deviation from it. To this very day, even though the law says something very different, even though the investigative judge, and I'm done in 1 minute, I promise, no longer exists, they're still utilizing the inquisitorial model. How are they doing it? Dossier no longer exists, so they're replicated in the judgment. Investigative judge no longer exists, so the trial judges are acting as the investigative judge. So even though these mechanisms and these formal institutions of the inquisitorial model no longer exist on the district and cantonal level, they're still using the model. On the state court level, they're no longer using the model. The change has been successful, but only since 2006. What happened in 2006? State Court of Bosnia-Herzegovina is very sui generis. One of the reasons is up until 2012, it was staffed by not only domestic Bosnian judges, but international judges from around the world as well. And some came from inquisitorial countries, some came from accusatorial countries. Post-2005, one thing they all shared is they all worked at the ICT, had worked at the ICTY in some capacity. And when you talk to these people, when you interview these people, you discover that post-2006, they put in place a training program to train their Bosnian colleagues on how to implement this new model. Last slide, I promise. So what are well, those are the findings. Legal recursivity matters, but it's heavily mediated by the institutional design of the institutions you're filtering the norms to. So in that sense, it's a very historical institutionalist framework, right? This school of thought within political science that says, institutions matter because they filter out the norms that you're talking about, the ideas you're talking about, the independent variables you're testing, the institutions they're filtered through matter. And so you can have similar independent variables across cases, but the outcomes are very different because the institutions they're filtered through are very different. Thank you.